So it's now 3 p.m. Thank you everyone for joining us. We're just going to wait a moment while everyone continues to filter in. All right, so before we begin, I'd just like to do some quick housekeeping. So this event is being recorded, and we will make the recording available to you after the event is over, and we also are going to post it on our YouTube channel. Your camera will not be on during the event, but you do have the opportunity to ask questions in the chat, and we will try and get through as many as possible. With that, I'd like to take a moment for a land acknowledgement. We recognize that many of us are joining from different places in Canada today, and we will not be able to acknowledge all the Indigenous lands our participants are living on. That being said, I would like to acknowledge that CCLA's office and the speakers of this event are in Toronto, which is the traditional territory of the Métis Nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. It is now home to many diverse First Nations, Inuit, and Métis people. In the spirit of reconciliation, we acknowledge the land that Indigenous peoples have lived on and taken care of since time immemorial. We are honored to be able to live on and work in this land. With that, I'm going to pass it over to our Executive Director and General Counsel, Noah Evangelson-Aviv, to give us an introduction. So Noah.
Thank you very much, Michael. And thank you, everybody, for coming here today, for joining us, for your interest in hearing more about the state of civil liberties in Canada in general, and specifically today about the state of fundamental freedoms and the role that we are playing, that we all are playing, both the team at CCLA and each and every one of you, to find out what we are doing, all of us, to stand up for these critical rights and freedoms on behalf of everyone in Canada. Before we get into our main presentation, I want to take this opportunity to share with you a few key updates from CCLA's other programs for rights and freedoms. In the past few months, it has been really quite a time. We've achieved some important victories and forward movements in the courts. I want to share with you just a few examples, but this is a small sample of everything that we're doing. The first decision I wanted to mention involves searches of electronic devices at the border, something many people have experienced. The question there that came up was, did Canada Border Services Agency, in fact, have the authority to search any and every electronic device, like they do with suitcases, with no reasonable basis, just a search for the sake of a search? The Court of Appeal, in a case called Pike and Scott, said no. This was an unconstitutional provision because it violated the Section 8 Charter right to be free from unreasonable search and seizure. CCLA had intervened in this case and argued that the border is not a charter-free zone and that standardless, limitless searches of electronic devices, which contain highly private information, violates the charter right to be free from unreasonable search and seizure. And the court indeed held that there had to be clear safeguards for the state to search an electronic device at the border because these devices are a trove of our most personal, intimate, and sensitive information, as CCLA had argued. Another case I want to mention briefly is one beautifully called Power, in which CCLA as an intervener won a victory for charter rights and state accountability. In that case, the question was whether the state can be sued if legislation that it passed is clearly unconstitutional or was in bad faith or an abuse of power. Could somebody sue for damages under the charter? And the Supreme Court held that in those circumstances, it could, and that there would be accountability for that kind of egregious violation. Another important movement forward that we achieved this very recently, as you may be aware, CCLA, together with two litigation partners, challenged Bill 21 in Quebec. This is the law that bans many public sector workers from wearing any religious symbol while at work. Those who've been harmed in particular are Muslim women teachers who wear the hijab. It has also affected Sikh men who wear turbans and work in certain public sector jobs, Jewish men and women who cover their hair with a kippah or a wig, and Christians who wear a cross or a crucifix, amongst others. It's now been through 2 courts, and the Supreme Court of Canada, which declines to hear most other appeals, agreed to hear our appeal in this extremely important case. The final update that I want to share with you is a case called Darthenay. It started with a person, a pedestrian, who was struck and killed by a speeding OPP, that's Ontario Provincial Police vehicle. Family of the victim filed a police complaint, and the OPP looked into it and decided that they were not going to pursue disciplinary action against the officer who was driving, providing no explanation for their decision other than to say that the police conduct in this case was, quote, not of a serious nature. No further explanation was given, and relatives of the victim wanted to hear more. The Ontario Divisional Court in Darthenay, in which CCLA intervened, decided that a person who files a police complaint has a legitimate expectation of receiving reasons if the police deem it not of a serious nature and fail to pursue disciplinary action. This is a victory not just for the family, but for every person in society. We have a right to know and understand how a police complaint is treated. Where the police cause a civilian death, it is the bare minimum for the public, let alone close family and friends, to understand the reasons for not pursuing disciplinary action. As I said, that's a very small sample of some of the key things that have happened in the last few months. And there's a great deal more that you find in our newsletters, and even more, and more importantly, on our website. I want to now turn it over to our main presentation. And so it's my great pleasure to introduce CCLA's outstanding Fundamental Freedoms Director, Anaïs Bussières McNicoll. In her role at CCLA, in this role, directing the Fundamental Freedoms Program, Anaïs is responsible for developing and implementing advocacy strategies in the areas of freedom of expression, freedom of religion, protest rights, democratic rights, and government accountability, all of which are top of mind in many, many places in the world at the moment. Anaïs does most of this with one hand tied behind her back, that is to say, in her second language. Anyone who has worked in their non-native language knows how difficult this is, and she does it brilliantly. Anaïs was called to the Quebec Bar in 2015 after completing her law degree at the University of Montreal. She then completed a 2-year-long clerkship at the Quebec Court of Appeal. Prior to joining CCLA, Anaïs was a partner at a national law firm where she practiced litigation, where her work focused on public and constitutional law as well as civil law, and where she was particularly solicited to contribute to complex cases at the appeal stage, including before the Supreme Court of Canada. So with that, it is my great delight to turn it over to our presenter, CCLA's Fundamental Freedoms Director, Anaïs Bussières McNicoll.
Thank you, Noah, for the introduction, and good afternoon to you all. It's a pleasure and a privilege to have this opportunity to present to you today some key issues I've been working on in my capacity as Director of the Fundamental Freedoms Program. As Noah mentioned, this program is devoted to protecting freedom of expression, protest rights, freedom of conscience and religion, freedom of association, democratic rights, mobility rights, and the rights to life, liberty, and security from government overreach. This program also focuses on democratic accountability and on upholding the rule of law. And while there was arguably no time in Canada's history when fundamental rights and freedoms were not threatened in some way, the current era calls for particular attention. In my perspective as advocacy director, I believe we're currently seeing increased state overreach in various aspects of our lives, be it through legislative, executive, or law enforcement actions. I'm talking here of both obvious and insidious state actions that participate to the gradual shrinking of our civic space. Just think, for example, of the federal government's invocation of the Emergencies Act, through which the government gave itself the power to adopt wide-reaching orders without going through the ordinary democratic process. You can also think of Bill C-63, the Online Harms Act, through which the federal government, among other things, wants to amend the criminal code to increase the maximum sentence associated with any offense in Canada to life imprisonment if the commission of such offense is found to have been motivated by hatred. If left unchallenged, we believe that these state actions can have dire consequences on our democracy. Because without a robust protection for our civil liberties, the free and democratic society envisioned by Section 1 of the Charter simply cannot exist. Now, this has been a very busy year so far for the Fundamental Freedoms Program, with CCLA being involved in approximately 20 litigation proceedings, either as party or as intervener, and a handful of important bills, and also countless press releases and media interviews on current issues that relate to civil liberties. But for the sake of today's presentation, which of course cannot last all day, I'll focus on 5 projects that are key to the Fundamental Freedoms Program. The first one I just alluded to. It's our Emergencies Act challenge, in which the federal court granted victory to CCLA and a few other parties last February. And you might remember that from the moment the Emergencies Act was invoked back in February 2022, CCLA raised concerns. We argued before the federal court that emergency powers are necessary in extreme circumstances, but that they are also dangerous to democracy. So this means that they should be used sparingly and carefully. And they cannot be used even to address a massive and disruptive demonstration if such disruption could have been dealt with through regular policing and laws. As argued by CCLA, the threshold for invoking the Emergencies Act is extremely high. It was the government's burden to demonstrate that there was an emergency arising from threats to the security of Canada, and that this emergency truly had a national scope. The federal court agreed with CCLA that this threshold was not met, and that the federal government's decision to declare a public order emergency under the Emergencies Act, as well as the associated regulations that it enacted, were thus unreasonable and unjustified. The federal court also found that the associated regulations violated the Charter right to freedom of expression and the right to be secure against unreasonable search or seizure in a way that is not saved by Section 1 of the Charter. So in other words, in a way that is not reasonable. As you may know, this fight is not over. It has now moved to the Federal Court of Appeal, and CCLA will file its factum in early October, and a hearing date on the merit has yet to be set. The second issue that caught our attention this year has to do with the right to peacefully protest and with freedom of expression. So, as you know, CCLA has been standing up for decades for free speech and the right to protest peacefully. And we have done so without taking sides or endorsing the meaning behind a specific expression or protest. We see these fundamental freedoms as true pillars of our democracy. These rights have played a key role in some of the largest movements for equality, privacy, freedom, justice throughout Canada's history. Just think of the creation of workers' rights, the fights against racism, against the denial of voting rights to women, and in favor of Indigenous peoples' rights. All of these debates were made possible because of the right of everybody in Canada to speak up, criticize, and dissent. And that's why we've been very active in the last few months on issues of free speech and protest rights, including as regards the student protest movement that has been active on several university campuses across Canada. CCLA intervened in the proceedings instituted by the University of Toronto in Ontario and by McGill University in Quebec. In both cases, the universities were seeking the dismantlement of the encampments erected on their campuses. We intervened in these cases not to endorse the expression at issue, but to argue that charter rights and values apply on university campuses. More concretely, CCLA argued that the mission of universities as institutions of higher learning require that the free flow of speech, opinions, and debate be encouraged and protected. We also argued that the communal nature of university campuses should inform the interpretation of universities' property rights and weigh heavily at all 3 stages of the interlocutory injunctions test. On July 2nd, the Ontario Superior Court of Justice granted U of T's application for an interlocutory injunction. So despite finding that there was no evidence of violence at the encampment, the court ordered its dismantlement. This part of the decision can be seen as disappointing. We believe it is regrettable that the court held that freedom of speech and protest rights do not allow protesters to camp, erect structures, and protest on university campus overnight, because we believe that this finding undermines an important aspect of protests, which is their disruptive nature. That being said, we were pleased to see that the court recognized the importance of charter values on university campuses, including freedom of expression, freedom of peaceful assembly, and freedom of association. The court also gave some concrete meaning to these values by recognizing that protesters could continue to protest on university campus during the day. As for the McGill case, it was discontinued further to the dismantlement of the encampment by a private security firm hired by McGill. We believe it is unfortunate that this case wasn't decided by the Quebec Superior Court, since the clear applicability of the Quebec Charter of Rights and Freedoms to the university's actions could potentially have led the court to a different outcome than the U of T proceedings. As a new academic year is starting, we're continuing to monitor the situation and have remained active. A couple of weeks ago, I sent a letter to the presidents of more than 70 universities across Canada to draw their attention to the utmost importance of making sure that their policies on protests respect students' fundamental rights and freedoms. In my letter, I identified key guidelines that universities should follow in the drafting of their policies on protests. The first one being that peaceful protests should be welcomed on campus and should not require pre-authorization. Whenever appropriate, CCLA is also glad to give input to government actors so that their policies and procedures align with the fundamental rights and freedoms of the people they are serving. For instance, a month ago, CCLA submitted its answer to the Toronto Police Service Board's request for public input on the overriding principles and key elements that should be a part of a new public order policy on police action in respect of protests. In CCLA's view, this policy is not about any specific point in time, debate, or community group. It's about establishing key principles that will guide the Toronto Police Service's conduct towards protests both today, tomorrow, and in the long term. CCLA's overarching submission is that fundamental freedoms should be at the center of the board's consideration when developing the policy. This requires meaningful acknowledgement that the police service, as all state actors, has a duty not to tolerate, but to facilitate peaceful assembly and to protect freedom of expression for everyone in Canada. Such acknowledgement starts by presuming that every protest is peaceful, unless there is compelling evidence to the contrary, and should not be limited. CCLA submitted that the police service's decision-making process around protests should focus on collaboration, the prevention of tension, and the promotion of de-escalation. The use of force should be avoided as much as possible, and if detention or arrest is necessary, justified, and lawful, the service should ensure the charter rights of people involved will be upheld in a timely manner. We also mentioned that the policy should require that the police service be accountable to the diverse communities that inhabit the City of Toronto. This includes identifying and meeting the needs of marginalized groups that take part in protests. Finally, we noted that the policy should highlight the importance of respecting protesters' privacy rights. That includes refraining from engaging in mass surveillance in the context of protests. But I want to be clear. All of that is not to say that CCLA is taking the position that free speech and protest rights are absolute. Carefully crafted, minimal limits may and sometimes should be imposed. For example, individuals and communities should not have to live with threats of physical harm or incitement to imminent violence. We believe law enforcement has the necessary powers to address such situations. But as a society, we should also be mindful of the distinction between speech that can be repugnant, offensive, or humiliating, but which is nevertheless constitutionally protected, and speech that is truly criminal in nature and which shouldn't be tolerated. So this leads me to the third key project I want to discuss today, which is CCLA's take on the federal government's Bill C-63. Bill C-63 is a bill of more than 100 pages that is separated into 4 parts. CCLA has several concerns with respect to the first 3 parts of this bill. But of course, legislation aimed at protecting against the harm of this online discourse serves an important purpose, particularly for vulnerable users. But CCLA's position is that any attempt at regulating online discourse by Parliament must give careful and meaningful consideration to the fundamental rights and freedoms enshrined in the Canadian Charter. As digital technologies evolve and grow increasingly pervasive in our lives, the importance of securing core individual rights grows as well. Part 1 of the bill proposed the Online Harms Act. This act would regulate 7 categories of content qualified as harmful through wide statutory duties imposed on social media operators and sweeping powers granted to the new Digital Safety Commission. Unfortunately, we believe that the act fails to place users' fundamental right to freedom of expression, as well as privacy rights, at the center of operators' considerations when complying with their statutory duties. In absence of adequate safeguards, and given the stratospheric amount of content posted on social media platforms, there is ample reason to believe that operators will seek to fulfill their broad statutory duties in a way that would unjustifiably and unreasonably limit free speech. CCLA's upcoming submission to the Justice Committee, which will be tasked with the study of this bill, will focus on proposing a revised approach that gives due consideration to freedom of expression and privacy rights, while also addressing democratic oversight and democratic accountability issues arising from the sweeping powers granted to the Commission. Part 2 of the bill is completely different. It introduces amendments to the Criminal Code that raise serious issues pertaining to proportionality of sentences, the presumption of innocence, and the right to liberty. First, the new offense motivated by hatred provision increases the maximum sentence associated with any offense in Canada to life imprisonment if the commission of such offense was motivated by hatred. We believe this potential sentence is irrational. It could lead to grossly disproportionate sentences and to an increase in plea bargaining from innocent defendants. As you might know, one key guiding principle to sentencing is proportionality. It requires that a sentence be proportionate to the gravity of the offense and the degree of responsibility of the offender. But instead of engaging in this exercise, the bill adopts a sweeping approach to sentencing by making life sentence available for any offense in Canada. We believe that for many offenses, particularly those of low to mid severity, the fact that the defendant was motivated by hatred against an identifiable group could never justify life imprisonment, regardless of the circumstances. Now, some of you could tell me that this doesn't really matter because life imprisonment would not be mandatory, but simply a possibility. The thinking behind this would be that judges will act as a safeguard to ensure the proportionality of the sentences. But we believe that the quest for proportionality does not begin in the courtroom. It must also guide lawmakers. And in other words, Parliament cannot abdicate its duty to enact proportionate sentences. Also, this type of potential sentence creates a very real risk that innocent defendants will feel compelled to accept a plea bargain in order to avoid the mere possibility of life imprisonment. It's well documented that the most severe penalties provide prosecutors with significant leverage to induce an accused to plead guilty. And we believe this risk will be even more present for vulnerable individuals who might not have the resources to engage with the criminal the criminal law system in a meaningful way. CCLA also opposes the new fear of hate propaganda offense or hate crime provision, pursuant to which a judge can order a defendant to enter into recognizance to keep the peace if there is a fear that the defendant might, in the future, commit any offense motivated by hatred, including hate speech. This peace bond could be subject to, quote unquote, any reasonable conditions, including requirements for the defendant to wear an electronic monitoring device, to remain at their place of residence at specified times, to refrain from going to any specified place, or to abstain from communicating with specific individuals. We believe that criminal law should be a means of holding individuals accountable for what they have done, not for what others fear they might do. Imposing deeply invasive conditions on an individual who's not even suspected or accused of having committed any crime, let alone convicted, unreasonably and unjustifiably infringes on several charter-protected rights. And if we take a moment and we pause here, we realize that this provision, as drafted, applies to fear of future hate speech. So it could be used to limit the expression or liberty of individuals who are expressing dissenting views, maybe in an unpleasant way, but still in a way that is lawful. So this provision carries the very real risk of chilling free speech in Canada. Part 3 of the bill proposes to amend the Canadian Human Rights Act to add as a discriminatory practice the communication of hate speech by any means of telecommunication, including the internet. While CCLA understands that the proposed amendments attempt to combat discrimination and promote equality, we believe that the Canadian Human Rights Framework is an improper mechanism to address the problem of hate speech in our modern society and risks leading to censorship of free speech. The proposed amendments would also increase the Canadian Human Rights Commission's ability to deal with a complaint without disclosing to anybody, including the person against whom the complaint was filed, the identity of the complainant. The complaint mechanism could thus very easily be used anonymously by individuals who disagree with speech that, while offensive, maybe doesn't qualify as hate speech. And we believe that this could be problematic, both from a freedom of expression perspective and from a resource standpoint. Because adding complaints about alleged hate speech to the commission's and tribunal's workload would require important resources, to say the least. Unfortunately, human rights bodies are chronically under-resourced, and the bill does little to nothing to remedy the current situation, let alone anticipate the additional needs that would need to be addressed. As you can see, I have a lot to say about this bill, which is why I'm involved in a handful of speaking engagements about it this fall. So for instance, 2 days ago, I was in Ottawa at the Digital Justice Summit organized by NCCM and Open Media to discuss this bill in front of various members of Parliament and policymakers. The fourth key project I wish to discuss today pertains to our challenge of arbitrary travel restrictions before the Supreme Court of Canada. Last July, CCLA and co-appellant Kimberly Taylor filed before the Supreme Court of Canada their factum in their challenge of the travel restrictions imposed by the government of Newfoundland and Labrador during the COVID-19 pandemic. Our position is that interprovincial travel restrictions infringe on the mobility rights of people residing in Canada. These mobility rights, as you may know, are protected by Section 6 of the Charter. We believe they should not be limited in a free and democratic society unless specific limits are necessary, proportionate, and as minimal as possible. The case's background is interesting. Back in May 2020, in response to the COVID-19 pandemic, the province's chief medical officer of health prohibited all individuals from entering Newfoundland and Labrador, except for residents of the province, asymptomatic workers, and individuals permitted entry in extenuating circumstances. Taylor, a Canadian citizen residing in Nova Scotia, was denied an exemption to enter Newfoundland to attend her mother's funeral. A week later, after submitting a reconsideration request, she was finally granted an exemption. No reasons were provided to her in either instance. CCLA and Taylor challenged the constitutionality of the travel restriction. In September 2020, the trial court found that the travel restriction did violate Section 6, but that this violation was justified under a Section 1 analysis. In other words, that it was reasonable in a free and democratic society to limit Section 6 in the circumstances. We took the case to the province's Court of Appeal. In August 2023, the Court of Appeal refused to settle the merits of the appeal, finding that the issue was moot, as the COVID-19 pandemic was now over and the travel restrictions had been lifted. In April of 2024, the Supreme Court of Canada granted us leave to appeal this case. CCLA's position is that even though the travel restriction had been lifted, the merits of the appeal should still be decided by the Supreme Court of Canada because of the tremendous importance of the constitutional issues raised and the dearth of jurisprudence addressing them. Whether Section 6.2 of the Charter does protect the right of Canadian citizens and permanent residents to travel freely across provincial borders, and what limitations may reasonably be imposed on this right under Section 1 are issues that are sorely in need of clarification. And in our view, the Supreme Court's involvement is all the more important in light of the near inevitability of a future emergency, be it public health, climate change, or even war, and the need for governments of all levels to plan for this eventuality in accordance with the Charter. Attorney generals of several provinces have announced their intention to intervene in this file, so the debate before the court is lining up to be a captivating one for sure. Lastly, I want to share with you that I'm monitoring closely active and upcoming provincial initiatives to increase the use of forced treatment on vulnerable members of our community. For instance, the Alberta government announced it would table a bill this fall that would subject drug addicts to involuntary treatment in facilities. The New Brunswick government is also expected to table a similar bill shortly. And just a week ago, the government of British Columbia also announced a plan to use existing provisions of the Mental Health Act to now force treatment on individuals with concurrent addiction, mental illness, and brain injury. And I agree that this issue is not an easy one, and substance use is certainly an alarming and pressing epidemic. So at first glance, forcing treatment on someone because the state believes it is in their best interest might appear like a laudable thing to do. But it is very clear that a person's charter-protected right to security and liberty is engaged when the state interferes with someone's ability to control their own body. Canadian courts have confirmed that the right to refuse unwanted medical treatment is fundamental to a person's dignity, bodily integrity, and autonomy. Courts have also found that forced treatment can constitute arbitrary detention in some circumstances. Now, of course, not all violations of liberty or security will be found unconstitutional. The question here is if a given violation is made in accordance with principles of fundamental justice and if it's reasonable. With respect to involuntary treatments, Canadian courts have in the past invalidated provisions of provincial acts that did not respect certain requirements. So, for instance, Canadian courts told us that one area of focus should be whether the individual in question is able to give valid consent or not. And you can have a mental illness and an addiction without necessarily being unable to give valid consent. And you might also be unable to give valid consent, but still want and deserve to remain involved in some way in the decision-making process behind your treatment. Also, Canadian courts have held that the categories of individuals targeted should be as limited as possible to achieve the state's purpose, and that the individuals targeted and their families should have access to simple ways to challenge a treatment decision. So I believe this is an important issue for our society, particularly for equity-deserving groups. There's no doubt that forced treatment disproportionately targets groups that are already marginalized, such as Indigenous, Black and racialized people, women, members of the 2SL, LGBTQIA+ community, people with disabilities, and those living in poverty. And history shows how pathologizing vulnerable groups, quote unquote, for their own good, can quickly become a slippery slope and turn out to be extremely harmful. One example of this is the coerced sterilization of women with mental illnesses, particularly Indigenous women, which was authorized by statute until the 1970s. So this is an example of why CCLA's role as a watchdog of the fundamental rights and freedoms of everybody in Canada is so crucial. So as mentioned, I've told you about 5 key projects, but the Fundamental Freedoms Program has a lot more going on. And I think all of it is on our website and social media platforms. I invite you to take a look at all the work we've been doing, and I really hope you will find it as important and interesting as I do. For now, I'd like to turn the attention back to all of you and to open a conversation. I'm eager to receive your feedback and to answer any questions you may have. Thank you for your attention.
Thank you, Anaïs. So, sorry, I misspoke earlier. Please put your questions in the Q&A section, not the chat section. We have about 20 minutes or so for questions. We'll try and get through as many as possible. So like Anaïs says, we encourage you to ask your questions now in the Q&A section. So the first question I have for you, Anaïs, is, as a director of the Fundamental Freedoms Program, what issues or threats to fundamental freedoms are of most concern to you right now?
That's a very good question. And as I mentioned earlier today, I think both obvious and insidious state actions can be problematic. But of course, that can mean many things. But things that are top of mind for me include suppression of speech, repression of peaceful protests. So that's why we're always monitoring very closely the news to make sure that if we need to speak up, we are speaking up. And if we need to monitor a potentially problematic situation, we are. Another top of mind issue, which is quite difficult to address in the media sometimes, is policing of hate speech. It raises question about what is hate speech, what is hate speech that should be prohibited, what is only maybe offensive or humiliating speech, and why on earth would we want as a society to let that type of speech go on? So this is a very complex issue which I'm always happy to discuss and to engage on. I think also one overarching theme of the work we've been doing in this program has to do with the use of public order or public health emergencies by the government as pretenses to override charter rights and freedoms. So I discussed earlier today the use of the Emergencies Act, also the travel ban case. So these are all precedents which we believed and still believe can be dangerous if left unchallenged. Because it sets a precedent for the government saying, oh, there was this big development, we needed to act fast, so we took this decision, that's okay, don't worry about it. And we think that in a free and democratic society, there should be a democratic process, it should be followed, and if there are exceptional circumstances, well, the government has the burden to establish that this was the case. So I'm certainly always monitoring issues that relate to that specific topic. And I think one last thing that is also very close to my heart and very top of mind is the increased use of the notwithstanding clause by governments, again, to override charter rights and freedoms. So as some of you might know, this is the clause which is within our charter and which allows governments to pass laws that violate certain rights and freedoms protected by the charter. And essentially, it was adopted as some kind of consensus back when the charter was adopted, and it was supposed to be used in last resort. And governments historically have stuck with that and have rarely used the notwithstanding clause. But unfortunately, I think we can say that this is no longer the case. And we've seen recently examples of provincial governments using or attempting to use the clause, for instance, in Ontario, to prevent education workers from striking. In Quebec, to ban some provincial government employees from expressing their faith through the wearing of religious symbols, or in Saskatchewan and now New Brunswick, in Saskatchewan mainly, to reveal the identities of trans youth to their parents before they are ready to do so themselves. So those are all examples where the CCLA, and not necessarily the Fundamental Freedoms Program, but all programs of CCLA is closely monitoring the use of the notwithstanding clause, and whenever appropriate, we're challenging that use before the courts, so that egregious uses of the clause in order to violate the fundamental rights and freedoms of everyone in Canada is not left unchallenged. And we're also working on a campaign to raise awareness with respect to this very important.
And with all the stuff you mentioned and all the stuff going on, how does CCLA decide which cases it will take on? Who decides this, and what criteria do you use to make this decision?
Thank you for this question. And I mean, of course, it's part of my duty to work on that. So as I mentioned, I'm closely monitoring the news. I'm reading court decisions. I'm monitoring new bills, whether it be at the federal level, provincial level. I'm reading all of those, and I really keep my eyes peeled for issues, violations of civil liberties. Now, of course, I'm sure, as you all know, we have limited resources. So I can't recommend to our executive director that the CCLA gets involved every time I see a rights violation. So we really have to focus on issues of systemic importance. And what that means is that, unfortunately, we can't get involved on a personal level with every individual who contacts us and says that they're suffering from an injustice. And whenever possible, we try to redirect these people to legal clinics who might be in a position to help them on a pro bono basis. But I think, yeah, so the criteria, I mean, what I have in mind, of course, systemic importance of the issue, also try to understand which communities it will affect, this issue will affect, and what are the perspectives? Are other organizations better placed and already involved with respect to this issue? Or is this one which I would say is an underdog, but that really deserves to be protected and fought for? And also, there's also this question of our capacity versus what the best advocacy tool is. Is it a press release? Is it a letter? Is it sometimes silent advocacy, having one-on-one discussion with interested stakeholders? Is it litigation? So that's everything that I have to take into consideration. And then, of course, I make a recommendation to our wonderful executive director, whom you met earlier, Noah Mendelssohn-Aviv, and we discuss this recommendation. And sometimes when it's very novel, we might even take this to the board to have their input. So essentially, that's how it works.
So one person is asking, if they want to see a draft of Bill C-63, where would be the best place to look for it?
So the ourcommons.com is the website where they have all of the bills. So you can, if you go on Google and you type Bill C-63 and keep your eyes peeled for the ourcommons.com website, you're going to find it. It opens a window, and I think you have to click on see the text of the bill. And then it gives you the most up-to-date version, which is the version that was tabled. Now, as the review in committee starts and progresses, there might be additional versions of the bill that will get added as amendments are approved or disapproved.
All right. And I'll add to that, if you want to see anything we've written on Bill 63, it's on our website, ccla.org. This is a comment, not a question. Well done. It's great to see CCLA so active on all these fronts. So thank you so much for that.
Thank you.
The next question, regarding Bill 21 in Quebec, civil liberties involves a balancing of rights, the rights of freedom of religion and the rights with the right of freedom from religion. Does Quebec and Bill 21 not achieve a fair balance of these rights, in your opinion?
That's a very good question. And I mean, This file is under the purview of our equality director, so Harini Sivalingam, so I'm sure she could give you a much better answer than I will, but I'll still try. And what I would have to say with respect to Bill 21 is that when the state, as is the case here with the Quebec government, is targeting individuals and prohibiting them from, well, asking them to choose essentially between practicing their religion in the way that they want to and practicing their profession, I don't believe this is a balancing of rights. But whoever wrote this is right that freedom of religion includes the right to be free from religion. But I think this should be understood in a way that the state does not get involved to target the practice of some religions and to the detriment of other religions. So, for instance, if you practice Catholicism, well, this religion does not require that you wear visible signs. So in other words, frankly, you don't care about Bill 21. It doesn't do anything to you. This is very different for people of other religions. So I would challenge the assertion that this is allowing people to be free from religion. I think this is targeting certain individuals. And I think also there's, of course, no evidence that by forcing, for instance, a Muslim woman to remove her hijab for her to practice her profession, it won't make her any better. So there's no added value for the population. What there is evidence of, to the contrary, is that many women or other individuals will choose to not to practice their profession because their religion is their identity, and they will not compromise that. So I believe that this bill is not only to the detriment of individuals personally, but also to the Quebec society as a whole, because we're deprived of very valuable people who just won't engage with the government and won't have won't occupy those positions because they won't compromise on their religions, and frankly, they shouldn't have to.
So this next person first wants to thank you for an excellent presentation. We want to know, we know that Indigenous women in Canada have experienced forced sterilizations without consent as recently as 2019, and we are grateful for the Canadian Medical Association acknowledging the need to educate to prevent this, to end it being used in the medical workplaces of Canada. Like, how do we ensure this happens across the country?
I'm sorry, I think I missed the last part of the question. How do we ensure that what happens?
I think they're wanting to know, how do we ensure that issues such as maybe you talked earlier about forced treatment, so like things like forced treatment, forced sterilizations, how we ensure this doesn't happen across the country.
So I think all of this goes back to two very important rights. I think it's Section 7, the right to life, liberty, and security. Section 15, the right to equality, to be equal in the face of law. And we know that historically some very marginalized groups have suffered from the hands of the states, who was quote unquote acting with their best interest at heart, but that ended up not being the case. So how do we make sure that this never happens again? I think it's an ongoing fight, and I think we need involvement from community members. So I invite you to reach out to us whenever you feel that maybe the CCLA could have a valuable input with respect to a specific issue. As I was saying, I'm monitoring the news every day. We're discussing among advocacy directors, but we can't see everything across Canada, and that's where we really need all of you to keep us in check and to make sure that whenever there's an issue that requires our involvement, we know of it and we can act in a timely basis.
Can you speak on the use of tools like AI in surveillance and protesting and how those infringe on our rights?
Sure. So what I would say is that we, as everybody in Canada has the right to engage in lawful activities with a certain degree of anonymity. So what I mean by that is that my conception of privacy rights is that the state is not allowed to know where I am at every moment. And the state is not allowed to know what I purchase, what causes I endorse, if I'm protesting in favor or against a certain situation. That's part of my right to anonymity. So when you're talking about, for instance, the use of AI, facial recognition technology, drones in the context of protests, what you're talking about is sometimes the police using those opportunities to surveil or even to profile people who attend certain protests. And then we can think that they might use this data to build up their database and to say, oh, okay, this individual was there this day, she was there after that, and the other day, she's clearly like, this is not something that we want as a society. And there's a line not to cross, of course. So if I engage in criminal conduct, well, of course, I don't have a right to anonymity. And of course, so I think it's all a question of balancing, but I certainly have very specific concerns about the idea of the state using mass gatherings, such as protests, to surveil us and to profile us.
I have another comment for you. So this person just wanted to thank you for the marvelous work you're doing maintaining Canada as a place of free expression. The next question I have, if you have any information on it, is regarding Bill 293. They're saying that this implies the regimentation of social and economic life, the ends of pandemic and ends pandemic preparedness, according to the World Health Organization. I don't know if you have any knowledge about that, Bill.
You got me on that. Unfortunately, I don't, but I'll certainly look it up afterwards. So I don't know if there's a possibility for me to get back to whoever wrote this, but I don't have thoughts to share today, unfortunately.
So whoever wrote that, if you want to send an email to us, you can send it to me, mlowry@ccla.org, and we'll make sure Anaïs can get back to you on that one as well. We don't have an answer for that one right now. Sorry, I'm just waiting for the next question to come through. So can you please speak more about the notwithstanding clause and what should be done to prevent its increasing use?
Sure. So I think a couple of things, really. We have some fights that are ongoing before the courts. So for instance, we think it's very important, for the electorate, so for everybody in Canada who's allowed to vote, to know that a government invocation of the notwithstanding clause is really used to shield an unconstitutional act from a declaration of invalidity. So in other words, we need courts to tell us if some laws are unconstitutional. And the way governments have been using the clause recently is to try to shield their act from judicial review. So they're preemptively using the clause, saying, oh, now courts, you can't even tell us if this wasn't constitutional. I guess we'll never know. And then every 5 years or so, every 5 years, actually, the government can reuse the notwithstanding clause and continue this problematic attempt and violation of constitutional rights. So one fight we're leading right now is in front of the Saskatchewan Court of Appeal to really have it recognized that even though the notwithstanding clause has been used, the courts are still entitled to make a declaration saying, well, had it not been used, the law would be invalid, the law would be unconstitutional. And we think this will inform the electorate, and maybe they will take a different decision the next time they're called up for an election. Maybe they won't elect this government again if they know that the government is infringing on the fundamental rights and freedoms of everybody in Canada or of a particular group in Canada. So that's one example of the work we've been doing in front of the courts. Another example, of course, is our challenge in Bill 21, which is going hopefully in front of the Supreme Court of Canada. And what we're doing there is slightly different. We're saying there is a limit to where you can go with the clause. And yes, it wasn't drafted in a way where we can like we can identify specific rights such as freedom of expression. Technically, the way the clause was drafted, governments could decide tomorrow that you can't disagree publicly with the government. That would be a clear violation of freedom of expression. But if the government uses the notwithstanding clause, technically, it's all fair game. We disagree with this perspective and this perception of the clause. We believe that our constitutional architecture is stronger than that, and that there are core values which we can all agree on, which even the clause cannot override. So that's why we're going all out in front of the Supreme Court to try to have the court recognize the importance of this constitutional architecture.
So I have one last comment, not a question. They just wanted to express their deep appreciation for what you're doing. This was the first time they attended a CCLA session, so they want to thank you for all your hard work. So it is now 3:55, so just so we can get this wrapped up by 4, unfortunately, this will be the last question. So we apologize we couldn't get all the questions today. So after this, Anaïs and Noah, you can do a quick wrap up. So what are CCLA's views on how we as a society should deal with free speech of political leaders and other influential citizens? That while perhaps not rising to levels of hate speech or protected by law, is dangerously inflammatory or demonizing of others and is leading us in the direction of authoritarian rule under which civil liberties are even less protected.
This is such an interesting question and an interesting topic. And I mean, we're certainly very aware of the suffering and of the pain arising from very polarizing views, from intolerance, be it coming from politicians who maybe have a bigger outreach, but also from quote unquote ordinary individuals. And we're aware of the pain and suffering that this is causing, particularly to marginalized communities and to equity deserving groups. So we would never want to be seen as endorsing such type of speech. This is absolutely not what we stand for. But that being said, we are also here, a part of CCLA's mission is also to be here to remind to everybody the importance of encouraging the free flow of speech, of ideas, and that includes the right to criticize and to dissent. And yes, our courts have told us that this freedom of expression includes the right to be offensive, to even be humiliating and even repugnant in some ways. And sometimes I wrestle with that, because what value can there be to that type of speech, right? But we think that the best way to fight problematic speech is through counter speech, is having people go out there and engage. If you disagree with a politician's view, well, say it and say it loud and explain why. But we don't believe that stringent prohibitions on speech are the way to go, simply. So, and as mentioned earlier, there are certainly limits to what can be said. And I mean, threats of physical harm, threats of death, incitement to imminent violence against an identifiable group, that's all issues that really, like, there's a criminal prohibition and there's a good reason for that. But outside of those very extreme form of speech, our position is that the solution is education rather than prohibition.
Thank you so much for that wonderful, wonderful presentation, Anaïs. You can hear how much everybody appreciated and enjoyed it, and the incredible work that your program is doing, and all of CCLA's programs are doing. And I'm sure we will make sure to send out to you information about other sessions that we're going to be having on the different advocacy program work. And I want to echo what Anaïs said, which is that the way in which we make change in a democracy, the most important way to make change, we can go to the courts, we can get rulings, we can go to Parliament, we can ask for change, but the most effective way to make change is for the general public to come out and have their voices heard loudly. That's why protest matters so much. That's why freedom of expression matters so much. That's why we have to tolerate a certain amount of expression that not everybody likes or agrees with, because we don't want to put the censorship power in the hands of governments that are making decisions, this government or any other future government. That's why it's so important. That's why we do so much media, to engage the public, inform the public about what's happening, so that you can participate and be part of the changes that we all want for this country. So I want to thank you all for wanting to know more, for attending the webinar, for your ongoing participation and interest in CCLA and in the work that we're doing, for your tremendous support for rights and freedoms in Canada. Anaïs, I want to thank you again, not just for preparing this presentation, but for answering so many different questions so brilliantly. We're very fortunate to have you leading this work for CCLA. And as Anaïs pointed out, and as I pointed out, the information that was shared with you today is a fraction of the tremendous work that our tiny team is doing. There is so much more, obviously, that we want to do, and we're aiming at growth. But to find out all the different things that we're doing, our website is the best place to get that information. So please do feel free to go there. If you're not on our newsletter as well, feel free to sign up for that. And thank you again very, very much for joining us and for being part of our work.
So thank you, Anaïs and Noah, for an excellent presentation. So it's 4 p.m., so we're going to end it there. So just a reminder, this was recorded. We will be making this available to you afterwards. And we hope to see you with the next one of these presentations. We'll be having a couple months, so keep an eye out on your email for announcing that when we announce that. But see you later, everybody.
Thank you.